Good afternoon, ladies and gentlemen. Maybe you'd like to come a little bit closer to us, that we can create a kind of community, or, yeah, as you said, or a workshop atmosphere. And you are free to ask questions and to create a little bit a vivid discussion, kind of. The topic of this roundtable is just right, international media rights, and the text says the media rights business is complex, also because there are differences that are specific to countries and regions, and maybe we can provide a little overview over this different legal regulations and the practice to trade media rights here on the panel and in the discussion with you, the audience. First of all, I'd like to introduce the participants of the panels. To your left, it's Lawrence Brown. He's media attorney. After studying law, Lawrence Brown trained and qualified into the media group of the city law firm Richard Butler. Now it's called Reed Smith LLP, from where he moved to become a partner in Davenport Lyons Media Group from 2000 to 2008. He now has his own law firm as Lawrence Brown Solicitor. Lawrence specializes in advising on the development, financing, production and distributing of film and TV programming and in related rights, as well as in connection with other copyright works. In the middle, it's Malte Behrmann, lawyer and managing director for politics of the German National Association of the Game Developers and General Secretary of the European Game Developer Federation. After law studies in Bonn and Munich, Malte Behrmann pursued audio-visual communication management in Valenciennes, France. Besides his legal and university work, Malte lectures at Game Academy in Berlin and in different institutions in France. Malte co-founded the German National Association of Game Developers and serves today as the organization's management director for politics. As General Secretary of the European Game Developer Foundation, he also works actively on game development issues at the European level, which is very interesting for our discussion, the European level, to stress this. Charles-Edouard Renault, on my side, partner of media and entertainment from Paris. Charles-Edouard Renault is an international business lawyer with more than 15 years of experience in intellectual property, copyright law and entertainment activities. Admitted to the Paris bar in January 1996, Charles-Edouard Renault has worked in private practice for both French and foreign clients. Charles-Edouard is advising French and foreign TV channels in regulatory law and copyright law, and including litigation aspects of judicial and administrative courts. And also, you have done a lot of film rights, as far as I know. First of all, I would like you to describe a little bit your daily practice. What is complex about your daily work with media rights? Maybe we start on the left side. By Lawrence. It doesn't work? Don't get my microphone.
Oh. Yes, that one's working, yes. Yes, so, well, my daily practice is primarily concentrated within the film industry. in terms of advising primarily film production companies, film producers, sometimes authors, writers, occasionally directors, and in other occasions financiers, people putting money into films. The complexity is not necessarily, from my perspective, as a day-to-day practitioner, a rights perspective or a rights complexity. Rights do have to be very carefully handled. I think that we feel within the film industry in terms of being aware of rights that can be traded, that our legislation is probably sufficient and up to date. I can't comment on copyright infringement legislation and piracy because in the UK we probably have a different legal system or legal practice to the continent in that we tend to specialise according to whether we are litigators and handle court processes and sue people for infringement, and whether we're really transactional lawyers who assist the client to paper and mesh and work through a complex transaction, and that's the latter that I do. So I don't see the court process. I'm aware that that's the area in which, of course, all countries have had to improve their legislation, and that there's been a battle over what to do as between the rights of people to use products and the rights of other people to protect their copyrights. The complexities, I think, arise out of the process. That's the message I always give when I give talks to people who want to get involved in a film production financing transaction. My general perception is that people completely underestimate the process complexity of what is involved. There are often quite different kinds of players involved. There are individuals, there can be private investors, there can be banks, obviously very large banking corporations, there can be tax intermediaries. It can be quite complex, and it certainly takes time to mesh that transaction together, and that is the nature of a closing process. So that's where I think the complexity lies, and that's where I think you have to be very aware. And within that, of course, then there can be complexity of rights, and there has to be an understanding of how you can see rights as a bundle of things, and you can then pull that bundle out into different strands. And of course, as people involved with rights, you should definitely be aware of that. And as I was saying in a small panel I did this morning, when acquiring rights, you obviously try to acquire rights as broadly as you possibly can, but when granting rights, you should only grant rights on a very limited, restricted basis, and always ask the question, why does the acquirer need to have that particular strand of rights? And very often they don't.
Thank you.
Yeah, I mean, I think I represent a little bit the games industry on this panel, so maybe I should concentrate directly on things which are different in the games industry than in this film and TV business. I think what is similar is that the copyright or author right issues, which are so interesting to the lawyers, are actually surprisingly little of interesting for the industry, because either they have the rights or they don't, and sometimes there's maybe a lawsuit, and then every lawyer is happy because finally you have a complicated question to be answered. But most of the time, these questions are not the daily practice. Daily practice is actually guiding people through the jungle of financing and organizing production and stuff like that. This is pretty similar to the games industry. What is different in the games industry is that we have higher risks.
Why?
We have higher risks in the game developers. I mean, you can compare the relationship between game developers and game publishers a little bit to the relationship between film producers and television companies or television broadcasters, or probably more accurate on a legal basis, like film distributors, but not on an economic basis. And the difference is that you have to have take much higher risks at the beginning of a new project. You have higher costs on a daily basis, which just appear, what we call the burn rate of a studio is higher than a film studio, which can actually shrink down to a very limited number of personnel if no film is in production. And this is not possible for the games industry, because you have to keep some technology in house. So you have to keep some parts of the company running all the time, even when you don't produce one of your big titles. This is one of the problems you have. You actually have a burn rate of considerable amounts, so the risk is higher. On the other hand, you have less public measures to support you. The film industry has been around for a while, and they have had, obviously, very successfully, very nice measures to get public support in different parts of the world. A little bit less in England than in France, but also in Germany we have these kind of measures. And that also helps a little bit, especially in the very early stages of the project development. So there are reasons why it is actually more risky to develop a game. I think this is a very interesting remark, because people from the outside always look at the games industry as this unknown stranger, which is obviously rich. And more they don't want to know about. So actually it is more complicated than that. There are different individual companies or individual players, actors involved in the value chain who don't necessarily, at least in the classic distribution, we will maybe talk about digital distribution in a minute, in the classic distribution, don't receive the same amount of revenue from the project.
Thank you.
Well, as far as France is concerned, I would first remind that the film industry last year in France generated a global turnover of 1 billion euro, if you take all different sectors and activity, production and post-production, exploitation. So it's indeed a huge sector, and as you just said, it's also quite an ancient one. But just to quickly remind how the public money and support came to the French film industry, it's thanks to our American friends, because after the Second World War, they wanted to have access to our market, and the counterpart was to structure that subsidy system that then have been copied and inspired in other countries. So my practice is as the one of an American lawyer based on entertainment, and entertainment include the film industry I just mentioned, and television, broadcasting and production. In France, both are markets strongly regulated, and it's partly thanks to the regulation that the copyright market is highly stimulated. If you take, for example, the TVs, being public TV or private TV, they have to invest a certain amount of money in production, and in local production and European production. Our French independent authority, or French independent audiovisual authority, the CSA, is looking to the fact that all those channels did invest a percentage of their turnover into the production, being audiovisual or the movies. And presently, this independent audiovisual authority is looking to